Wearable electronic data trackers have become popular recently. Fitbit, Nike's Fuel Band, and Jawbone are electric devices that can be worn, which will track the calories that a person burns in a day, the number of steps taken, whether any stairs are taken, whether the person has been running that day, etc. All of this information is then recorded and uploaded to a smartphone or a computer. Now, when you are in a motor vehicle collision, your health is, of course, in issue. And so a question has arisen whether or not this wearable technology data that has been accumulated by victims who have been wearing the Fitbit, for example, pre-accident, and then wearing it again post-accident, there's an issue whether that information must be disclosed to the defendant auto insurance company. Typically in Alberta, any information that is considered, quote, relevant and material, end quote, as it's outlined in the rules of court, is disclosable. The question is whether or not this electronic Fitbit or Jawbone data should be disclosed. This was recently an issue before the Nova Scotia Court of Appeal in a case where an individual was running a home-based internet business, and thus the defendant auto insurance company wanted the metadata, as it's called, of the computer pre-accident, which would show his hours on the computer, how long he worked pre-accident, versus his hours post-accident. The Nova Scotia Court of Appeal decided to grant that information to the defendant auto insurance company with a couple of cautions. One of the cautions was whether or not the information was reliable. In this case, the court held that the computer metadata was reliable. But when we come to a Fitbit, an electronic tracker that is allegedly tracking the number of steps that you take or that you are in fact running, that is very much a live issue whether that data is really reliable. And so basically where we're at today as to whether or not you would have to disclose that, in our view at Handel Law Firm, that information is relevant and material because as a victim you've put your health in issue. The question, the real live issue in our opinion, is that that information is not reliable enough to be disclosed because it has not been shown that a Fitbit or a Jawbone perfectly tracks the number of steps or perfectly tracks the number of calories that a person takes. These are only estimates. And I mean, it's become widely popular. But when it comes to a legal argument as to this person is engaging in X number of activities now after the collision, and that's very similar to what they're engaged in pre-accident, and therefore they may not be injured, that's an entirely different matter. That information from a court's point of view would have to be very reliable if the court is going to make a determination on that. So in our view, that information should not be disclosed. It would be up to the defendant auto insurance company to prove to the court that a Fitbit, for example, provided very reliable information that the court should rely on in making its decision.